We're going to start this video by looking into the International Covenant on Civil and Political Rights, Article 2.2, where it states the following: where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So what do we see coming out of that article of law, out of that expression? We find that there are rights recognized in the covenant, and that if no mechanism of enforcement exists in domestic law, then the executive have promised and undertake to take the necessary steps to give effect to the rights. So this is an obligation that rests upon the executive and the legislative. If there is no operation of law, no mechanism that exists in domestic law which gives effects to the rights that are in the International Covenant, then there is an obligation upon you to produce a mechanism or a measure to give effect to the rights. We learned the following through that article of law in the International Covenant. The mechanism to enforce the right can be a legislative measure. It can come through a statutory power, an enactment, or a regulation. 2. The mechanism to enforce these rights can come through the Constitution, the ground or foundational law of the nation. The last measure or mechanism of enforcement is designated something called other measures, but they're not specific to what these other measures are. Some would say that the only way that our rights can be enforced is through legislative measures, meaning the government had to provide a way through the enactment or regulation directly, and if they failed to produce the measure, then we are out of luck, and there is no hope for an individual to enforce their rights. This line of reasoning and thinking is not correct, and it is possible to become poisoned by this straw man argument. It does not matter who is bringing forth this argument, even if it is a person acting in an official position. When we are talking about court, about the fact that our rights have been limited and abridged, and enforcing our fundamental rights and freedoms, we find that what really matters is what does the Supreme Court of Canada say or state concerning this fact. All lower courts are bound to the judgments and determinations of the Supreme Court. If a lower court judge rules in opposition to the Supreme Court, that judgment is mute. So let us look a little closer at that straw man I mentioned above. You know, the one that states that unless the legislator directly implemented our rights in the enactments, they are not enforceable. Baker versus Canada. Now, this case is cited over 5,000 times within the SEC, and it states that the principle that an international convention, international law, international rights, ratified by the executive is of no force or effect within the Canadian legal system until incorporated into domestic law, does not survive intact the adoption of a principle of law which permits reference to an unincorporated convention during the process of statutory interpretation. Here we are seeing that the Supreme Court stated that to believe that our rights in the International Covenant have no force or effect in domestic law, in Canadian law, until they are directly incorporated into the statutory laws is not a correct argument or judgment to make. Here we see a Supreme Court judgment from Health Services and Support, and it reads as follows: under Canada's federal system of government, the incorporation of international agreements into domestic law is properly the role of the federal parliament or the provincial legislators. So the judge is stating that it's up to the executive and the legislators to produce the operations of law, to produce the mechanisms to enforce these rights. And that goes along with agreement, what we just read in Article 2.2 of International Covenant, where it says they have the obligation. However, Canada's international obligations can assist courts charged with interpreting the Charter's guarantees. Here again, we are seeing the Supreme Court state that the obligation to incorporate or give effect to our rights has been placed upon the executive and the legislators. Some would want you to stop here and confuse you by saying, you see, the obligation is on the legislators, and if they did not incorporate or provide the measure to respect your fundamental right, then you are hopeless. They failed to understand the rest of the article, which states Canada's international obligations can assist courts charged with interpreting the guarantees of the Charter. In fact, we find that it is up to us to show the judge the operation of the right in international law to help define the right before the court. If the executives have failed to provide the mechanism to enforce the right, then it is up to every individual to enforce the right on their own. In order to describe the right that the executives have failed to allow us to exercise, then we can use the covenants themselves as a reference. DeVito versus Canada, Supreme Court Judgment. Canada's international obligations and relevant principles of international law are also instructive in defining the right. The content of Canada's international human rights obligation is, in my view, an important indicia of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents which Canada has ratified. So here we see the Supreme Court already declaring that Canada has international obligation towards the human rights and fundamental freedoms. We understand that these international obligations flow from Article 2.2. It placed the obligation upon the executive powers and stated you had to produce a process, you had to adopt such laws or other measures to give effect to these rights. And the Supreme Court is saying, listen, we understand that even if there's hasn't been a direct incorporation of these rights in statutory powers, it does not mean that the executive and the legislators have escaped their obligation. In fact, now it's up to us to go in front of the courts and show them that our right and describe our right internationally, that it has been limited and abridged, that the executive and the legislators are not respecting these fundamental rights and freedoms. As we can see, if our rights and freedoms have not been expressed or preserved for us directly within the enactment or regulation, or if the statutory power is limiting and abridging our rights, then we can turn to international law to define and express what right the executives are failing to honor. Now, more recently in Health Services and Support, again, it says the Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents that Canada has ratified. So here the court again is saying Canada has ratified these international human rights documents, and now some would want to teach you and lead you to believe that, well, unless that these rights have been incorporated into enactments and regulations, unless these rights have been incorporated into statutory powers, then you cannot hope to enforce these rights before the courts. Yet we saw before that the Supreme Court has already dealt with this issue by stating to us, listen, the principle that an international convention ratified by the executive is of no force or effect within Canada's legal system until incorporated into domestic law through those statutory powers does not survive intact the adoption of a principle of law which permits reference to an unincorporated convention during the process of statutory interpretation. So basically, let's break that down in a little bit more easier English to understand. It's stating that if we're complaining about a statutory power, and we're saying that this statutory power has limited and abridged our fundamental rights and freedoms, well, we can go to international law, show them the principle of law, show them the right that exists for us, that we're allowed to operate, that we're allowed to exercise, and then show them how the statutory power has limited and abridged that fundamental right and freedom. That's the responsibility that we have. R versus Hape, Supreme Court Judgment, Article 53. It is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. Now notice here the judge didn't say that legislation will conform to international law. He says that it will be presumed. They will presume it will. It will be deemed to conform to international law. Now, all judges in Canada are under the presumption that the statutory powers, the enactments and regulations, conform to international law. Why are they under this assumption? Because the Attorney General's office is given the duty to examine all enactments and regulations and then to make a subsequent declaration upon his signature or her signature, whoever is running the office at that time, declaring that after reviewing this statutory power, this enactment or regulation, that according to his or her legal opinion, according to his or her understanding, that these enactments conform to international law, conform to charter rights and freedoms, respect our fundamental rights and freedoms, respect human rights and freedoms. He signs off on that, and now the judges who sit in the judiciary are under the assumption, are presuming, that because the Attorney General said it's okay, that all these statutory powers respect our fundamental rights and freedoms. And it's up to us to show them that here we have a right in international law, and the executive and the legislators had the obligation to respect this right by producing a mechanism in domestic law to allow me to exercise the right. Now, not only did they not produce the mechanism for me to exercise my right, they went further than that. They limited and abridged my right. They are trying to take away my right. That's our obligation again. Because once we do that, we break the presumption that the judge is under. Because the judge is under the presumption that the Attorney General signed off on the bill and everything's okay. Now we show them, here's our right in international law. Here's our right supposed to be transferred into domestic law. They didn't do it. And not only didn't they do it, they limited and abridged the right. Baker versus Canada, Supreme Court. The values reflected in international human rights law may help inform the contextual approach to statutory interpretation and judicial review. The legislator is presumed to respect. You see, there it is again. Second judgment. We saw in R versus Hape, it's presumed that the legislators, the one who creates the enactments and legislations, the enactments and regulations, will be conforming to international law. It doesn't say that they are, but they're presuming that they are. The legislator is presumed to respect the values and principles enshrined in international law, both customary and conventional. These constitute a part of the legal context in which legislation is enacted and read. Insofar as possible, therefore, interpretations that reflect these values and principles are preferred. The important role of international human rights law as an aid in interpreting domestic law has also been emphasized in other common law countries, and he gives examples of what other countries. It is also a critical influence on the interpretation of the scope of the rights included in the Charter. So there we have it. 3 witnesses, very clear from the higher courts, that is teaching us the following. That the incorporation, the bringing forth, the transferring of our rights and freedoms from international agreements into domestic law is properly the role of the federal parliament or the provincial legislators. So, the executive or the legislators are under obligation to transfer, to produce a mechanism, to produce an operation of law that allows us to exercise our rights and freedoms. Now, this obligation is coming directly from the covenant in Article 2.2, where it places the obligation upon them. And the courts are recognizing this and saying they have the obligation, the executive and the legislators, to produce the operation or the mechanism for you to exercise your rights. Now, Baker versus Canada, the Supreme Court, told us that if these rights and freedoms were not incorporated into domestic law directly, it does not mean that they are not operable. It does not mean that you cannot stand upon them and you cannot seek to exercise them. Further to that, Baker told us that we can make a reference to these unincorporated conventions, to these unincorporated laws, to these laws that were not transferred into domestic law, even though they were obligated during the process of statutory interpretation. These laws that are flowing from the international covenants, from the human rights instruments, can assist the courts, which are charged with interpreting the Charter's guarantees. So they are there to be instructive, to define and to describe the right that we are claiming is being limited and abridged. DeVito versus Canada Canada's international obligations and relevant principles of international law are also instructive in defining the right. So we go to the court, we point to international law and say we have a right in international law. The obligation was upon the executive and the legislator to transfer this into domestic law. They haven't transferred it. They didn't make a provision, an operation, a mechanism for me to exercise my right. They're limiting and abridging my right. And now I'm seeking the court to protect me, to produce a remedy for me. We learned that the court is under presumption. They presume that all legislation respects international law, so it's up to us to show the court that our rights have been limited and abridged. How do we show the court that? Well, we go back into international law, we bring up the right that we are complaining about or we are trying to exercise that is being limited and abridged. We show them where the statutory power, the domestic law, the regulation, placed a limitation or abridgment upon that right, and then we ask for the remedy. This last judgment really has nothing to do with the information that's on this video, but it is a very powerful judgment, and it will help those who are seeking to enforce their rights before the state party. So I'm including it here. R versus El Dorado Nuclear Limited. Where the only source of the unlawfulness is a statute, however, the determination is entirely different. If a person commits an act prohibited by statute, and the Attorney General seeks to prosecute for violation of that statute, the preliminary question that must be asked is whether that person is bound by the statute. If not, the person simply does not commit a violation of the statute. The situation is not that the person is immune from prosecution, even though there has been an unlawful act. Rather, there has been no unlawful act under the statute. If you understand what that is saying, it's talking about jurisdiction, about the state party. Well, really, it's a corporate body, so we'll call it what it is. The corporate body Canada seeking to take jurisdiction over an individual through a statutory power. And they want to automatically take the color of right, take the authority over an individual, and claim that you owe a duty and an obligation to the statutory power. But we realize that many of these duties and obligations to these statutory powers, to these enactments and regulations, are actually limiting and abridging our fundamental rights and freedoms, our natural rights, our human rights and freedoms. So when the state party approaches us and says, we have jurisdiction over you, you owe a duty to such and such enactment or regulation, most of the time, this duty that they're trying to produce against you limits and abridges your fundamental rights and freedoms.